Welcome to sentencing in the Menzel OWVI case. The state has victims present, defense is ready, and restitution is already a flashpoint. Watch how timing, proof, and responsibility collide from fingerprinting to a heartfelt apology. Stay to the end and subscribe, like, and share for more sharp courtroom breakdowns
Menzel,
today.
defendant, is charged with 1 count of operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Alex Hill on behalf of the people. Also present are 2 of the victims in this matter. These individuals were passengers of the vehicle that was involved in an automobile collision. Will you please unmute Ms. Zuckerbrow Miller and Mr. Miller, and then separately state your names clearly for the record?
Joni Zuckerbrow Miller.
David Miller.
Thank you both.
Counsel.
If it may please the Honorable Court, good morning, Your Honor. Michael Okechukwu, P82535, on behalf of Mr. Ryan Menzel. State your name for the record, Ryan.
Ryan Menzel.
All right, and Mr. Menzel, is your middle name Matthew?
Yes, Your Honor.
Thank you. Today is the date set for sentencing with respect to the pre-sentence investigation. Are there any additions, deletions, or corrections on behalf of the people?
Your Honor, I would just note that the report indicates the restitution information. The people are in receipt of additional information, which they would like to submit to opposing counsel. I've advised Attorney Davis that we'd be requesting a restitution hearing in 30 days so that all of the evidence can be submitted. It is above average in the amount of the request based on the significant medical injuries. I would note, just so the parties are aware, we're asking for an amount that's going to be around $7,500. So we have no changes, but we.
Okay, so that's allocution, and you said that. Oh, I mean, I'm sorry. You said that the
Key legal moment, the court challenges the 30-day restitution delay because victims directed probation to their private lawyer. That undercuts the PSI process. Judges need timely, verifiable numbers to sentence fairly. Should late documents get another month, or did the window close when probation couldn't verify? Tell me your view below.
The PSI addressed the restitution, and that is not correct. The only thing the PSIR that I have said that the witnesses told my probation department to talk to their lawyer, which we're never going to do. So we tried to get restitution information, it sounds like, and then your witnesses said, talk to our lawyer. And so I'm not in, we'll never be interested in that. So what restitution information are you indicating, Mr. Hill? Because the witnesses were given an opportunity to present the restitution information to probation, and they declined to do so. And now you want me to go 30 more days to give them 30 more days to get the restitution information, and they didn't do it in the 30 days that I gave?
Respectfully, Your Honor, they did have a private attorney in Detroit who did not meet their expectations for client communication. I did have a conversation with him this week, and he was in possession of many of the documents that they needed to provide. After realizing that he was not assisting them in the way that they found satisfactory, they've done it independently. There's been no attempt to prejudice Mr. Menzel. I believe that these are reasonable requests related to direct injuries from this crash. And I do not think that a 30-day restitution request is out of the realm of fairness.
So I don't know that whether you misunderstood what I said, but I have a problem with them telling the probation department at all to communicate with their lawyer. I have a problem with that, whether their lawyer was communicating properly or not. It is probation's responsibility and duty to this court to gather the information that I need to give a fair sentence. And it's not appropriate to say, talk to my lawyer. We don't, if you want
Yeah, I'm on
restitution,
Brian right now for
you
Menzel.
want
We're doing the
restitution.
sentencing, and then this is
If you want restitution, you want restitution. And you want to give this court the information for restitution. And now you want me to have set a whole another day when today is the date. But nonetheless, tell Mr. Davis to move. We trying to do the sentencing. And he's standing in there. He's supposed to be. All right. Okay. Nonetheless, I hear your request. Mr. Hill, do the witnesses wish to make any statement today?
Yes.
I believe they do.
All right. And so, Ms. Zuckerbro Miller.
Yes, thank you very much. When I was contacted by the probation person, this was last week and I was caught off guard. I've never done anything like this before. And I didn't know what to say to her. So I said, I don't know, can you please talk to my lawyer? And then Mr. Hill explained that our lawyer wasn't responsive, and I sent him the receipts of the costs that we incurred. We had come to Detroit to visit our son who had just moved to Detroit 2 days earlier. We were in a Lyft car on our way to my son's house when we were hit on the highway. And my husband and I, who's sitting right here, we have still have not fully recovered from this crash. My husband has significant.
The Miller's testimony lands like a hammer. Hospital stays, lost work, forced retirement. This wasn't just a crash, it derailed futures. Their voices underscore why restitution matters. Justice is not only about punishing a defendant, but restoring lives. Can an apology and dollars truly repair the invisible scars? You decide.
Significant injuries. I'm still not fully recovered. And we never were able to even get to our son's house. We had to spend a week in the hospital. We were at Sinai Grace for a week. And then we had to stay in a hotel before we were well enough to fly home. And once we got home, my husband was a school principal at the time, and he couldn't start school on time and spent time recuperating from his concussion until about October. And after that, had so many doctor's appointments, he was really forced to retire at the end of the year, and that was much earlier than we had ever anticipated. So this accident has affected us tremendously and continues to. And I don't know if there's an end in sight.
Thank you, ma'am. Sir, would you like to say anything?
No, that's fine. Thank you.
Okay, thank you. All right, and is that all on behalf of the people? Mr. Hill?
Yes,
Okay.
yes, I was just making sure I didn't want to say anything else regarding restitution, but I think the people have said what they want to say.
Okay. All right. Mr. I see I'm messing. Okachuku.
okay, Chuku. Yes, Your Honor.
Okay, Chuku. Okay. Counsel.
Yes, first and foremost, additions to the PSI, Mr. Menzel would like to update his address as 410.
Oh, hold on, counsel.
Okay.
I knew Mr. Hill threw me off, and I said that was allocution, and then I still let him allocute. I'm sorry, counsel. I was really only on the additions, deletions, or corrections. So, we will update Mr. Menzel's address. However, today the court is live streaming, so don't say his address.
Okay.
You give that to the clerk. We'll call and give that to the clerk. And then the address that's on the pre-sentence report is a Kentucky address. Does your client live out of the state of Michigan?
Yes, Your Honor. My client is a millwright, so for work he travels literally 365 days of the year. He could be in a different state either weekly or bi-weekly. And so that is the issue. He hasn't been to Kentucky, he says, in over 2 years.
So how was he driving a Lyft in the state of Michigan?
He wasn't the Lyft driver, Your Honor. He was driving a different car.
Oh, that's
Correct.
right. You're right. Okay, yeah, my bad. You're right. The Lyft driver, they were in the Lyft, and then the Lyft. Yes. Okay.
Correct, Your Honor.
Okay, so we'll correct the address off screen. Is that still his phone number?
That is still his phone number, the 8,
Yes. Mhm.
yes.
Okay, all right. And then now you can also allocute. Mr. Hill had allocated and that threw me off.
One more thing, my client wanted to indicate that he was not arrested or fingerprinted as it states in the PSI report.
Mr. Flanagan, do we have a CTN number?
A CTN number, yes,
What's that other number that we're supposed to have?
but the TCN, we don't have that.
Oh, see, now they know those initials are too close.
Yeah.
So we don't have a TCN, which means he didn't get fingerprinted?
Yes, Your Honor.
Oh, your client has to get fingerprinted. So
Will the court provide a time frame for that to be accomplished? He's
I will.
currently in
We'll
Seattle.
talk about it in a minute.
Okay.
So we'll double back to that. And whether he gotta be in any given state, that might not go well for his probation counsel. I'm not sure, he might not be able to do that. But nonetheless, you can allocute now.
Yes, my client is a 34-year-old gentleman. Your Honor, this is a lot of times as criminal defense attorneys, we have to defend the indefensible. And one thing I've noticed since discussing with Mr. Menzel is that he takes full accountability for the accident that happened. He didn't blame his childhood. He didn't blame any outstanding stress. He acknowledges that what he did was wrong, Your Honor. He works as a millwright. He's unionized. And like I said, he could be in a different state, either bi-weekly or by the week, Your Honor. This incident was one that he's ready to take full accountability for, and he would like the court to note that he had one prior marijuana possession charge, but he really has a limited criminal history. And so we are asking the court at this time to respectfully adopt the recommendation of 12 months of probation. And I'm confident that this will not happen again. Mr. Menzel did indicate that as of yesterday or 2 days ago, because this accident happened in 2023, he has been sober from alcohol or marijuana for over 2 years, Your Honor. His last drop was, I believe, on 6/9 of 20. No, the interview was on 6/9, but his last drop in June tested negative for alcohol or THC. So that shows that he's taking this seriously, and he's taking the steps to not have controlled substances be a part of his or hindering him in the future. One last thing about the PSI, it indicated no firearms possession or use. My client indicates that he's a hunter. Hunting season is around the corner. No firearms were the cause or even part of this incident, Your Honor. So he's asking that at least to that portion of the recommendation of probation that he be allowed to maintain use of his firearms. And I'll leave the rest to Mr. Menzel, Your Honor.
All right, Mr. Menzel, you wish to make a statement to the court?
Yes, Your Honor. First and foremost, I'd like to sincerely apologize to the Millers. And in regards to the restitution talk, I have absolutely no problem paying that $7,500 restitution that was requested. I can pay as much as $2,000 a month until that's paid off towards those people, because like I said, I sincerely apologize. And every day since then, it just seeing their face on the Zoom call right now made me feel horrible hearing their statement. Yeah, like he said, I'm on the road for work and that guy can't work anymore, and that's because of my actions. And I truly regret that, and that makes me feel horrible to hear them say that. And yes, I will absolutely pay that. There's no argument.
A rare twist, Menzel shocks everyone by offering full restitution without hesitation. No legal wrangling, no denial. His apology was raw, emotional, and even the judge admitted it was among the most sincere statements in 18 years. But sincerity doesn't erase harm. Should genuine remorse weigh heavily in sentencing? Big question.
There at all, so we can just go ahead and do that $7,500, and I will pay that off as soon as possible. And ma'am and sir, I really do apologize to y'all, and I really hate to hear that I impacted y'all's lives negatively, and I wish y'all nothing but the best going forward. And I really am sorry that I'm the reason y'all are not okay.
Well, that's one of the the most, that's one of the, I don't want to call it the best, but that's one of the most sincere defense statements that I've had in my 18 years on the bench. Mr. Hill, did you say $7,500?
Roughly, Your Honor, yes, we believe that's going to be the ask. I don't have a specific tabulation in the documents. I can submit those to counsel and perhaps we could stipulate to a reasonable amount.
All right, well then, Mr. Menzel, I want to say thank you for taking responsibility. I am thankful always that that things didn't turn out worse, because drinking and driving is one of the most irresponsible things that we can do. It's not the only irresponsible thing that we could do, because it's just as bad to be sleepy and drive. The results of being sleepy and drive is just as bad as being drunk and driving. The results of reaching down and looking at your phone and texting is just as bad as drinking and driving. So it is one of the most irresponsible things we could do, but it's not the most irresponsible thing we do. And so just like their Mothers Against Drunk Driving over the years have been a formidable force in the criminal justice system, it is becoming inclusive of those other things. Texting and driving, sleepy and driving, all of those things are bad. And so, but I appreciate you accepting responsibility. And usually if an individual is able to accept responsibility, it does deter behavior in the future. Your statement that you feel bad listening to the victims is also, I thought that it was sincere. And that is one of the reasons that the Victims' Rights Act exists, that they may have an opportunity to be heard, and for a defendant to see the impact that their behavior has had on other people. Now, I'm going to sentence you in a way, though, Mr. Menzel, I don't know. I'm not going to limit your ability to work, especially since you want to pay this restitution, that your lawyer will at some point stipulate to the amount. So Mr. Hill, I'm going to give you 30 days to submit that. I'm not saying that I'm going to set a hearing. Mr. Menzel has indicated he will basically stipulate to 7,500. Of course, if it's less than 7,500, that's good. If it's more than 7,500, we'll see what that more is and whether his attorney will stipulate offline. I'm not saying that in 30 days I'm giving a restitution hearing. I'm saying I'm giving 30 days for you to submit that and for you all to come to an agreement. And then if not, I'll see if I'm going to do something above the 7,500. So the way I hear it is that Mr. Menzel is stipulating to 7,500 or less, and then we'll see what happens if it's anything more. So I am going to say restitution to be determined at this time, but I'm going to make note stipulated to 7,500 and 30 days to submit.
If I may, Your Honor.
Receipts. Yes.
Usually, just in the course of practice, we would never tell our clients to admit, to fault.
I know he did that without your.
Exactly. This is why we got him on no contest plea. But that goes to why I believe that he's a sincere candidate and should at least the recommendation for probation should be followed and give him a chance to show that he's being forthright with the court, Your Honor.
I agree. Now, but what we also know, and what you will know, Mr. Menzel, is you paying 7,500 through the criminal justice system. I don't know what the result of any civil action will be, but you don't have to pay. You won't have to pay double. Like you won't have to pay this 7,500 again. So let's say it's a judgment. Let's say, I don't know, for 20,000. I don't know, in the civil. you get credit for this 7,500. This 7,500 is going directly to the plaintiffs, to the victims. It comes through the court, but we're going to send them a check every time we get restitution. We send them a check. So just so that you're aware. Okay. The court is going to impose the following sentence. I will accept the recommendation for 12 months probation. Mr. Menzel, he has a short criminal history. You said one case, Mr. I gotta look
Okay,
up.
Chuku.
Okay, right there. Okay, yes, I'm gonna get it. Okay, Chuku. You said one case. The PSIR says 2, but the one of them was way in 2008, and then the other one was even distant in 2018. They were both sort of dealing with, it looks like marijuana maybe. So nonetheless, I am going to accept the recommendation for 12 months. I need a 12-month date, Miss. Oh, look at him. He already put it in the chat. I love my clerk. A 12-month date would be on July 20th of 26. And then I'm going to give Mr. Menzel a halfway date with me. And if at this halfway date, Mr. Menzel, if you have completed all the terms and conditions of the probation, which is going to include the restitution, then you will be eligible to be discharged early from probation. Now, if you don't do it by this midway date, that's fine. We'll just continue you to the July 20th date, but the midway date that you would be eligible to be discharged early, I'm going to set it at January the 26th. I'm sorry, January 21st, excuse me, January 21st, 2026. That review will be at 10 o'clock. If you have completed the terms and conditions of probation, you will be eligible to be discharged early. And then, if, as I said, if not, we will continue you to the July date. The terms and conditions are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. I am giving consent, okay, for Mr. Menzel to leave the state of Michigan. However, Mr. Menzel, please know that your travel schedule is not going to be able to interfere with the conditions of the probation. And one of the conditions of probation is going to be urinalysis. Now, the court, I don't know what your work is, right? I don't know what your work is. It may be more convenient for you to be on an alcohol monitor or, you know, the Hell Hand PBT, although those do not test for some of the drugs that I may need it to test for. However, you tested negative when you came in to test. And so really, I'm only most interested in alcohol because this is a drunk driving case. So what I'm saying to you is, as a part of your probation, I would order you to test once a month, random testing once a month. That's my normal OWVI testing requirement. However, based on your travel schedule, that may not be convenient for you, which means I will approve the handheld PBT or the alcohol tether. Now, know that those devices require more than once a month. Like the handheld PBT, you might have to blow in it, you know, whatever times a day. Now, I will still say once a month or, you know, once a week, but I think the way those function and operate, of course, the alcohol monitor is monitoring you all the time for alcohol. And those are potentially a little bit more expensive, but that's what I'm going to order. So I'm going to order random urinalysis once a month or PBT or alcohol tether, and I'll let probation explain those to you better, and you can see which one will allow you best to continue to work. Because here's the thing, random urinalysis, I don't care where you are in the world. If you get called to go take a drug test, you have to go. Now, so that would mean you would have to find a site in Washington. You would have to find a site in Tennessee. You would have to find a site here, wherever you were. So work that out with probation. All right. Additionally, you must notify probation immediately of any change of your address, phone number, or employment status. You are going to pay the following fines, costs, and fees. Mandatory cost of $210, a $300 fine. As I indicated, restitution is to be determined. Supervision fees for 12 months is $420. If you're discharged early, that amount will be prorated. The 6-month amount is $210, but it's prorated based upon whatever month past 6 months you get discharged. Court is going to impose the $100 as assessment fee and pre-sentence investigation substance abuse evaluation. I am not going to include the urinalysis fees in your probation order because it sounds like you are going to be testing away from the court or getting on one of the other devices. So your total fines, costs, and fees are this is excluding the restitution and any amount you may have to pay for classes or the PBT devices, $1,030. As I previously indicated, the people have 30 days to submit the amount for the stipulation, if it's $7,500 and or less, and then if it's above that, then we will see what the if the defense will stipulate to an amount above that. And once the 30 days is, so we're going to put it on my docket, Mr. Flanagan, for a 30-day review for restitution.
Okay.
And all right. Additionally, sir, you shall not use or possess any illegal substance. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiate without a valid prescription and letter of explanation from the doctor. You cannot consume alcohol in any form. You cannot drive without a valid driver's license. You must complete the Alcohol Highway Safety Education Level 1 program. And the programs that I am going to order you to participate in, it is my understanding that they are all available virtually. They're all available online. The Alcohol Highway Safety Education Level 1, you will attend the Victims Impact Panel, watch the consequences video. And if there are any positive tests, there could be a referral. There will be a referral to outpatient treatment. And you will attend the Driver's Improvement Program. There was a recommendation for Marijuana Insight, but he didn't test positive for marijuana, and so I'm not going to order that.
Thank you.
I don't know why there's a recommendation about firearm. I'm not going to order that. So they do recommend the alcohol tether, and maybe it's because they knew he was traveling like he is. So the alcohol tether, as I indicated, I will allow. Now, your Michigan license, it says on the report, is suspended and restricted. So I don't know what license you're driving on or if you have a, valid license, but make sure you do. And then, yeah, I think that that's going to conclude the court's order. You will pay any outstanding tickets you have with 36th District Court and clear up any warrants, but according to the report, you don't have any. And yes, that's going to conclude the court's order. We're going to mail a copy of this order to the address that counsel is going to call and give to the clerk. I didn't want him to give it on live stream. And then we will contact you. Probation will contact you at the phone number ending in 5691. Anything further from the people?
No, thank you, Your Honor.
Anything further from defense?
Nothing further. Just what is that court's phone number once again?
313-965-2295.
2295. I'll be calling shortly.
All right, then we're all set. And then Mr. Miller and Miss Zuckelbro Miller. Okay, so make sure that the prosecutor has your correct address. As I previously indicated, the way that the restitution works, Mr. Menzel will pay the court. It will be included in his probation order. So when I receive the stipulation, I will update his probation order. It will go into the court system. When we receive the money from him, we are going to mail you a check. That's how it's going to work. So make sure we have your correct address so that we can mail you the check. Because if it gets returned to us, you know, then that's a lot of stuff. So just make sure Mr. Hill has your current address, and as that money comes in, we will mail it to you. I guess they might mail it once a month or something like that. Okay.
Thank you.
Thank you.
All right. You're welcome. Anything further from anyone?
None, Your Honor.
Everyone, have a great day. Stay safe.
Thank you. Thank you, Your Honor. Thank you, Mr. Clerk.
You're welcome.
12 months probation, restitution, set alcohol testing, and strict conditions. The court balances accountability with the chance for redemption. This sentence highlights how acceptance of responsibility can reshape outcomes. What do you think was justice served here? Like, comment, and subscribe for more shocking courtroom stories you won't want to miss.